So Leon Nicolaou's case then, which I suppose is the first case that really clarifies that this provision protects only the marital family. It's a case that's decided in 1966. So it's right in the middle of the so-called activist era, or right, I suppose, at the start of the so-called activist era of Irish constitutional law. Gladys Ryan's case has just been decided a year previously. Mary McGee's case comes shortly afterwards, and a whole load of other cases on criminal procedure and loads of other cases that in retrospect are looked back upon as having been decided by a progressive minded court. So it's in that context that Nicolaou is decided. Yet read the judgment and you'll see, you'll be struck by it. But anyway, so the facts are kind of beautifully set out by Ruan McCormick in that book that I mentioned so often on the Supreme Court, chapter 6. Can I please repeat the case name? Yeah, I will indeed, Debbie. Thank you, Nicolaou. I'm just gonna write it down here. It's a tricky spelling. I hope I get it right. I'm just gonna check it. Nicolaou. Nicolaou. Now let me just check. Let me just check that I have the spelling right. Nicolaou. Yeah. Nicolaou. Against where am I? Minister for Justice, is it? Or the Attorney General? I'm a little bit. I remember. Oh, sorry, Jesus, yeah, An Bord Uchtala. So I'm glad now I looked that up. Oh, sorry, I answered it. Please public message me, guys. I mean, seriously. I want to send this to everybody. Oh, Christ. Yes, thank you. Yes, that is exactly right. Yeah. Alex. So there you go. An Bord Uchtala. I'm embarrassed that I got the respondent's name wrong. Is the adoption board. So it was against the adoption board. An Bord Uchtala is the Irish for adoption board. Okay, so yeah, so the facts are set out very nicely, and it's in chapter 6 of Ruan's book, and it's well worth the read, actually. Anyway, so Leon Nicolaou is a man. He's Greek Cypriot guy living in London in the 50s, and he owns a cafe somewhere in North London. And Kathleen Donnelly is an Irish woman, young Irish woman at the time from Galway, who travels to London seeking work, ends up working in Leon Nicolaou's cafe. And she falls in love with Nicolaou, or they fall in love with one another, and she becomes pregnant. And actually, Ruan, as he tells the story, Ruan McCormick interviews the baby, who's now middle-aged, of course, Mary Carmel, and he tells it from her perspective. So I actually remember where I was when I read the Ruan McCormick chapter, because it's actually quite an affecting story. And it's interesting in the context of this week as well, or this month, with the Mother and Baby Homes Commission of Investigation report being published, because ultimately Kathleen Donnelly, the woman, the mother, ended up, or was in, a mother and baby home, certainly for a period of time, on the Navan Road, Dublin, which is one of the mother and baby homes that was considered by the Commission of Investigation. Anyway, this is kind of mid-50s, late 50s into early 60s, and so she becomes pregnant, comes home to Galway, is writing over and back to Leon Nicolaou back in London, sorry, bear with. So they separate, and Kathleen begins to suffer mental health difficulties, ends up in the mother and baby home, and ultimately decides that, or maybe a decision is made for her, I don't know, but that the child is going to be put up for adoption. And Leon Nicolaou objects, all right? as it happens, as part, you'll see yourself when you read the story, but basically, Kathleen Donnelly went back to London, and the relationship apparently was revived for a period of time with Nicolaou, but eventually just didn't work out and they separated. But then Nicolaou is living in London, working in London, and really pining after his child, But he writes to the adoption board on Bord Uchtala and says, look, I object to this adoption. So the child is put up for an adoption, and like a 6-month period has to pass before the adoption order is finalized. In that period, he writes to the adoption board, says, I'm not okay with this. I don't give my consent. But because of Section 14 of the Adoption Act at the time, 1950 something, the father's consent is not required by the adoption board. So the adoption board basically keeps his objection on file and says nothing, and the adoption proceeds. And Mary Carmel is adopted. And as it happens, and this is interesting, I guess, in the context of everything this month, but Kathleen Donnelly explained to Leon Nicolaou that her concern was that if she allowed Nicolaou to raise the child, that the child might not be raised a Catholic, because he was a member of the Greek Orthodox, had been, I think he had been a member of the Greek Orthodox Church. So there you go. Anyway, eventually Nicolaou does challenge the adoption board, hence the case on Bord Uchtala. But as part of that challenges the constitutionality of the Adoption Act, the provisions that make it unnecessary for the father's consent to be obtained. And a critical part of his claim was that, this was a family, or he and his child, if you like, were a family for the purposes of Article 41, and that this was an attack on the constitution and authority of the family and was unconstitutional. And Seamus Henchy was in the High Court at the time, hadn't yet actually been appointed to the Supreme Court, but decided the case in the High Court, and couldn't have been clearer. But that Article 41 protected only marital families and therefore availed of nothing for Leon Nicolaou. Okay, and I think it is worth casting your eye over an excerpt from the Henchy judgment. I won't read it all out now. For those of you who got the book, it's on page 477. But Article 41 deals with only one kind of family, namely the family founded on the institution of marriage. He goes on to talk about how it's not just really Article 41.3 that brings about that result, but it's Article 41 read in its entirety, refers to the notion of this family being deemed to be indispensable to the welfare of the nation and the state, and effectively is kind of saying, well, how could it be that non-marital families would be seen as such? I'll come back to that, Lucy, thank you. I'm satisfied that no union or grouping of people is entitled to be designated a family if it is founded on a relationship other than that of marriage. If extended to units of people founded on extramarital unions, such interpretation would be quite inconsistent with the letter and the spirit of the article. It would be tantamount to recognition of such units as, quote, necessary for the basis of social order. And he's kind of effectively, the implication is there that he's kind of saying it couldn't be that non-marital families would be thought of as necessary or indispensable to the welfare of the state. Okay, and Brian Walsh, on appeal to the Supreme Court, Brian Walsh says something similar. Right, now, bear with me a second. A couple of other little things that warrant mentioning about Nicolaou's case. One is that Kathleen Donnelly, the mother of the child, obviously neither does she have any family rights vis-a-vis her child or with respect to the whole situation under Article 41. After all, she's unmarried as well, of course, but she is deemed, and unmarried mothers are deemed to have rights to custody and care of the child flowing from Article 40, personal rights of the Constitution. Right, Article 40, unenumerated rights, for instance, the personal rights. right to custody and care of the child. And this came up in another case called G and the Bord Uchtala, G against the adoption board. But natural fathers did not have rights under that provision. Now, there is a kind of a famous passage from Brian Walsh's judgment in Nicolaou, where he justifies that or talks about why it would be that fathers would not have rights under Article 40. I'm talking about now, not 41, 40, and mothers would. And just bear with me while I read it out for you, if I may, on page 486 of the book, for those of you who have it. When it is, so just listen to the comparison that he makes between different kinds of fathers as he sees it. Okay. When it's considered that an illegitimate child, which was the language of the day, right, may be begotten by an act of rape, by a callous seduction, or by an act of casual commerce by a man with a woman, prostitution, as well as by the association of a man with a woman in making a common home without marriage, in circumstances approximating to those of married life. And that, except in the latter instance, it is rare for a natural father to take any interest in his offspring. He says, when it's considered all of that, it's not difficult to appreciate the difference in moral capacity and social function between the natural father and the natural mother. Now that reminds us of Article 40. If you have the Constitution in front of you, you can look at it. I don't know, like Article 40 talks about equality, obviously, right? It opens up with the provision on equality, with the wording, phrase on equality. Let me just get it for you here. All citizens as human persons shall, as human persons, be held equal before the law. So Nicolaou is being treated very differently from Kathleen Donnelly here. This shall not be held to mean that the state shall not in its enactments have due regard to differences of capacity, physical and moral, or of social function, right? Which reminds us then of that point we were talking about earlier, that you can treat different cases differently, right? That's not necessarily a breach of the equality provision. And here then we see Brian Walsh in Nicolaou saying, well, look, fathers are different from mothers, because fathers aren't interested in their offspring. Basically equating the rights to custody and care, or in this case to have their consent to be relevant to an adoption order. Fathers who are fathers in virtue of a rape, or who are fathers in other circumstances, have the same rights. You know what I mean? So it is Brian Walsh, like the doyen of Irish constitutional law, the great so-called great judge of the Irish Constitution. I suppose, in fairness, this isn't his finest hour, but there it is. That's what was decided in the Nicolaou case. Now, you might think that that's of its time and is no longer relevant, but that's not true, actually, because in a case called MacD and L from 2010, MacD against L and M, I think it was, Miss L, or L and M, they were a lesbian couple. Now, this is before marriage equality, 2010, 2007, 8, 9. And they wanted a child, the couple. And so availed of their friend, Mr. MacD, who was a friend of theirs, who donated sperm. And the agreement in advance was that MacD would have a relationship of a kind of a favorite uncle type relationship to the child, or to any resulting child, but wouldn't be a parent. Okay, so of course time passed, the child is born, and things change, and relationships sour. And eventually there's a guardianship and access dispute, and MacD wants access, and the lesbian couple say that they're going to emigrate to Australia. And a case comes before the High Court ultimately concerning guardianship and access. And Hedigan, at the time in the High Court, John Hedigan was the judge, and he found that the lesbian couple and child were a family for the purposes of Article 41, which I suppose was a radical thing to do, right? Because it was obviously a radical shift from Nicolaou, but also if you think about it in the context of the language of Article 41, founded on the marriage and so on. So Hedegan, relied on Article 8 of the European Convention on Human Rights, which protects a right to a private and family life, and has been interpreted to protect non-marital as well as marital families. Actually, at the time it hadn't been, but that's another story. But then relied on that to interpret Article 41 in light of it, which was problematic reasoning, to say the least. Okay, problematic reasoning. It was appealed to the Supreme Court, and the Supreme Court judges who decided the case couldn't have been clearer or more emphatic. Denham, Fennelly, and others, all in their judgment say, look, Article 41 does not protect non-marital families. The lesbian couple, in this case, don't count as a family for the purpose of Article 41, can't rely on Article 41. John Hedegan had erred in doing so. And it wasn't like as if they were being cruel or cold or callous. The judges were just, the judges, after all, have to interpret the Constitution. They can't make it up as they go along, you know. So, and even more recently, in 2018, around the time of the abortion referendum, just in advance, actually, of the abortion referendum, in a case called M against the Minister for Justice, which was a pretty obscure case concerning a couple that were being deported, but the mother was pregnant and it concerned the rights of the unborn child, you know, because was the child a citizen? It's a complicated case. But the judge in the High Court was a guy called Richard Humphreys. He's still in the High Court. Interesting judge, but he decided the case in a rather unconventional manner. And as part of that judgment, talked about how with the marriage referendum that had happened and with all of the divorce referendum that had happened and all of the various social evolution and legal change that had occurred since Nicolaou, that basically Article 41 now would protect non-marital families, right? And that was appealed to the Supreme Court, and the Supreme Court under Frank Clark, the current Chief Justice, handed down a judgment where he said, and you can read about it in the book, but basically, look, Humphreys was wrong. Here, Article 41 just protects marital families. So, in other words, the point couldn't be clearer, okay, as a matter of Irish constitutional law. So let's leave it at that for this week. I'm going to hang around and stay here if anybody wants to ask me anything. Let me just see, stop